Good morning, good afternoon, good evening, Omojuku, depending on your location. Please subscribe to our channel, like and share our videos so that you help us propagate the truth. The news updates. British High Court kicks against IPOB leader Nnamdi Kanu's illegal rendition to Nigeria. Ejimako reveals. Now the British High Court has made an unconventional ruling in a significant human rights case centered on Onyendu Nnamdi Kanu, a British national and leader of the indigenous people of Biafra, that's IPOB. Onyendu had approached the court to challenge the United Kingdom's government for not defending him despite being a citizen against the Nigerian government. His legal team, led by John Hartford, head of public law and human rights in Binsman LLP, has said that in June 2021, Kanu, was abducted from the airport in Nairobi, Kenya, by Nigerian security services and was detained and tortured for around 10 days in Kenya. He was then flown blindfolded on a private plane to Nigeria. But in a statement on Thursday, Alhaji Mako, special counsel to Onyendu and IPOB, said though the UK High Court frowned at his rendition to Nigeria, it however ruled that the Foreign Secretary did not have to reach the same conclusion. He said the court also highlighted extracts from the opinion of the UN Working Group on Arbitrary Detention and the Nigerian courts, which unanimously found that Kanu, the leader of the IPOB, was subject to extraordinary rendition and which called for his release. The Working Group on Arbitrary Detention is under the United Nations Commission on Human Rights, UNCHR. Now, the group comprises scholars and experts who specialize in human rights issues and related laws. In its report on July 20, 2022, the UN group described Onyendu's repatriation from Kenya in June 2021 as illegal, unlawful, unconstitutional extradition. It also called for the immediate release of the IPOB leader and compensation by the Nigerian and Kenyan governments for the way he was treated. In the document, the body also indicted both Nigeria and Kenya for Onyendu's abduction and rendition. Despite the call by the UN Working Group, the Nigerian government has, however, failed to release the leader of the IPOB, Onyendu Nnamdi Kanu. Ejimako said, I quote, while making the revelation, whilst Mr. Justice Swift noted the findings of the UN Working Group on arbitrary detention and two separate rulings from Nigeria's High Court and Court of Appeal that Mr. Kanu had been extraordinarily rendered to Nigeria following his interception in Kenya by Nigerian security forces, and observed himself that Mr. Kanu had been subject to rendition. He went on to hold that the Foreign Secretary was legally entitled to make no decision on whether this is the case or not. Binsman LLP, the legal team acting for Mr. Kanu's family, described the ruling as extremely difficult to reconcile with the long-standing legal precedent and the principle underpinning it. Mr. Kanu's case was heard over 4 months ago on 15th November 2022. In today's judgment, Mr. Justice Swift noted the evidence of serious wrongs having been committed against Mr. Kanu, including that in 2017, the Nigerian state had attempted to kill Mr. Kanu, for which a Nigerian High Court awarded compensation and an order for apology. That the Nigerian authorities captured Kanu in 2021 whilst he was in Kenya and subjected him to inhuman and degrading treatment, and crucially that he was subject to rendition. However, despite clearly recognizing the gravity of the wrongs committed against Mr. Kanu, the court disappointingly held that Mr. Kanu has no legitimate expectation that the British government should reach a firm view for itself on what had occurred or its seriousness. This is particularly surprising given that the court itself reached the view that Mr. Kanu had been rendered on the basis of the evidence before it. The court's judgment is unsatisfactory, not just for Mr. Kanu, but for any British national who finds themselves subject to a serious violation of their rights whilst abroad. It effectively enables the Foreign Secretary to prevaricate indefinitely in the face of such a violation, and consequently limits the steps the British authorities should take to assist a British national even in circumstances where there is unequivocal evidence of that violation. The Kanu family has appealed against the judgment. Reflecting on the judgment, Kingsley Kanu, who brought the lawsuit, said, "The UK High Court has now joined the Nigerian High Court and Court of Appeal and the United Nations in recognizing correctly that my brother was subject to extraordinary rendition. That is something of importance. But I find it very disappointing that, in spite of this, the High Court has held that the British authorities are not required to reach a decisive view on his rendition and can refuse to confront the mass of evidence of what has occurred. Until the British authorities reach such a view, it is impossible for them to properly consider what steps should be taken to assist my brother." Kanu's family is represented by John Hartford and Sharon Marker of Binmas LLP, together with Charlotte Kilroy Casey of Blackstone Chambers and Tatiana Atwell of Dahati Street Chambers. Ms. Sharon Marker said today that despite taking 4 months to decide this case, the High Court has produced a judgment that is extremely difficult to reconcile with long-standing legal precedent and the principle underpinning it, which is that British citizens abused abroad are entitled to expect decisiveness and protection from the British government rather than years of hand-wringing procrastination. End of quote. And this is the British government. You see, they have to be decisive about this. Instances abound where the British government have gone all out, to extricate their citizens from harm in other countries. So why this is a different case, we are asking. Why is Onyendu's case different? That the federal government has been torturing, manhandling the leader of the IPOB. Right from Kenya, everything was wrong. Yes, there is a legal backup to it. The appeal court judgment is there to tell you that these things are quite unfortunate. Yes, you went to Kenya, you collaborated with the government of Kenya, you abducted someone, you tortured him over there for 10 days. Now you extraordinary rendition him. While on transit, you still torture him. At home, when he landed, you torture him. While in the detention facility, you torture him. Court said all these things are wrong. The international community, through the human rights, said all these things are wrong. UN working group. Abia State High Court said, look, it was an attempted murder on him. Attempted assassination on Onyendu on 2017. You see? So these are the things, but the United Kingdom is supposed to understand this and be firm and decisive to extricate their own citizens. We are watching because we are seeing it from the angle that the federal government of Nigeria is influencing the UK. The UK is supposed to be seen to be firm and to be reasonable.